They figured I was nothing more than a rancher they could intimidate into giving up his own property. So the Homeowners Association dragged me into court, insisting that my 1,900-acre ranch should fall under their authority. What they never expected was that the truth had been sitting inside an old filing cabinet since 1952. By the time the courtroom battle was over, they wouldn't just lose the lawsuit, they'd lose the only road leading into their neighborhood. Before we get any further, let me know where you're watching from. Leave your country in the comments because I always enjoy seeing how far these stories travel. And if you haven't subscribed to HOA Revenge Stories yet, now's the perfect time. Hit that subscribe button, because what happens next is even more unbelievable. My name isn't important. The land is. 1,900 acres of open pasture, cattle fences stretching across the hills, and a winding creek that's been part of my family's ranch for 3 generations. My grandfather purchased the property in 1961. My father spent the next 40 years raising cattle there. When he passed away, the ranch became mine. In 2003, developers built a subdivision along the eastern edge of my property. Before long, they established a homeowners association to oversee their streets, clubhouse, and neatly organized suburban community. That never bothered me. I stayed on my side of the fence, and they stayed on theirs. Somewhere along the way, though, the HOA board convinced themselves that part of my ranch, the gravel road cutting across one corner of my land, the same road my family had been using long before their subdivision even existed, had somehow become shared community property. The first letter they mailed me actually made me laugh. The lawsuit that arrived later erased that smile. It began with a certified letter claiming the HOA possessed long-standing rights to maintain and control the gravel road, crossing my ranch, the same road I'd used for more than 20 years to move cattle, tractors, and ranch equipment. Then they crossed another line. One morning, while driving out to repair a broken water line, I found bright orange HOA signs stapled directly onto one of my fence posts. Community Access Road, do not obstruct. I immediately called the HOA president. She spoke calmly, almost as if she were explaining something obvious to a child. That road has always been considered shared infrastructure. Shared with who? I asked. My grandfather bought this property outright. As far as I knew, there had never been any recorded easement. I made it clear the answer was no. That single conversation changed everything. 3 weeks later, a process server handed me legal papers. The HOA wasn't making requests anymore. They were suing me for allegedly denying an established right of access. Then my attorney uncovered something that didn't make sense. When she requested the county plat maps and development records, the HOA's complaint referenced an access agreement that supposedly existed when the subdivision was first planned. The county couldn't find it. There was no recorded filing number, no signatures, no official document. Nothing. The only thing anyone could produce was a modern map showing a road running through my property and into the subdivision. Yet there wasn't a single legal document proving that route had ever been authorized. If no agreement existed, why were they acting as though it did? At the time, I didn't realize that one question would eventually unravel their entire case. The HOA's attorney came out swinging from the beginning. His argument was simple. He claimed decades of neighborhood use had created what's known as a prescriptive easement. If enough people openly use a roadway for years without the owner stopping them, a court can sometimes recognize permanent legal access. My attorney, Denise, never looked worried. Prescriptive easements require open, continuous, and, most importantly, uninterrupted use, she explained. If we can prove that use was interrupted, their entire argument falls apart. There was just one problem. We needed evidence reaching back decades. Maybe my father had kept something. Maybe he hadn't. As far as I knew, any proof we needed had disappeared long ago. Meanwhile, the HOA's lawyer walked into every hearing wearing the same confident grin, as if the verdict had already been decided. I was beginning to wonder if he was right. Then, during a family dinner, my aunt casually asked a question. "Didn't your grandfather save every piece of paperwork, contracts, letters, everything in that old filing cabinet inside the barn office?" I hadn't opened that cabinet in nearly 15 years. Hidden beneath stacks of faded cattle sale receipts and decades of ranch records sat a single manila folder. Across the front, written in my grandfather's unmistakable handwriting, were 4 words: right-of-way, revocable, 1952. We hadn't just uncovered the evidence we needed to defend ourselves. We had stumbled onto something the HOA never imagined anyone would notice. That gravel road wasn't simply an access route for the subdivision. Hidden deep inside the county's infrastructure records was one detail the developer had overlooked more than 20 years earlier. It was the subdivision's only legal entrance and exit, and every inch of it crossed my property. When the trial finally arrived, the HOA walked into the courthouse with an army of attorneys and board members dressed like corporate executives attending a quarterly meeting. I walked in with Denise, one battered banker's box packed with my grandfather's records, and a level of confidence I hadn't felt since this whole nightmare began. The HOA's attorney started aggressively. He portrayed me as an unreasonable landowner who was selfishly blocking a neighborhood that had supposedly depended on that road for generations. Then Denise rose to speak. One document at a time, she guided the judge through the evidence. First came the 1952 revocable right-of-way agreement. Next came my father's 1978 letter officially canceling that permission. Finally, she presented the county's own infrastructure maps, proving the subdivision's developer had never secured a permanent recorded easement before building an entire neighborhood that relied on crossing my ranch. The HOA's lawyer still insisted that decades of continuous use created a legal right. Denise didn't hesitate. "Continuous use of a permission that was legally revoked," she said, "doesn't create an easement. It creates decades of trespassing that simply went unenforced." The courtroom fell silent. Then the HOA's original developer took the witness stand. Under oath, he admitted that no permanent easement had ever been recorded. He had simply assumed the 1952 agreement was still valid. An entire subdivision had been designed and built around an assumption that had legally ceased to exist back in 1978. The judge called for a short recess. When she returned to the bench, I could read the outcome on her face before she spoke a single word. The decision was devastating for the HOA. The court ruled that no valid easement existed. Their claim of a prescriptive easement failed because the original 1952 right-of-way had been formally revoked in 1978, decades before construction of the subdivision had even begun. Their lawsuit was dismissed in its entirety, but that wasn't the end of it. Because I had filed a countersuit for trespassing, the court addressed that issue as well. The judge ruled that I had absolutely no legal obligation to continue allowing anyone to use the road. Any future access across my property would require my written permission. Permission that I was under no obligation to provide. For the first time since this dispute had started, the confident smile that had stayed on the HOA attorney's face through every hearing completely disappeared. Because that gravel road wasn't just another neighborhood street. It was the only road leading into the subdivision. Within a week of the ruling, I installed a locked gate across the road and posted clear, "No trespassing" signs, all completely within my legal rights. The reaction inside the neighborhood was immediate. Emergency responders, delivery drivers, utility crews, school buses, and hundreds of residents had depended on that route every single day for more than 20 years. Without it, homeowners suddenly found themselves making 45-minute detours over narrow back roads that had never been intended to handle daily traffic. The same HOA board that had been so eager to sue me now faced angry residents at every meeting. People demanded answers. How had no one verified something as basic as a legally recorded easement before approving and building an entire subdivision? Eventually, the HOA came back to the negotiating table. This time, the conversation happened on my terms. I agreed to allow limited access in exchange for annual payments under a carefully drafted legal agreement that made one fact unmistakably clear. The road belonged to me, the same HOA that had once stapled warning signs onto my fence without permission now sends me a yearly payment simply so its residents can drive to their own homes. They sued me, hoping to take control of my land. Instead, they walked out of court, having lost the only legal route across it. Looking back, the most unbelievable part isn't that I won. It's how close I came to losing everything because of one forgotten folder that nearly ended up in a burn pile during an old barn cleanup. If my aunt hadn't remembered that filing cabinet, if my grandfather hadn't saved every document he ever signed, if my father hadn't taken the time in 1978 to officially revoke that right-of-way, the HOA would probably control a piece of my family's legacy today. Instead, they learned an expensive